We're going to start with medical mediation, and then we're going to deal with the recent case that you guys saw, probably regarding a doctor being arrested for murder. I'm not going to deal with the case in particular because I'm sure all of you have read what was said about it, but rather how it can happen that you can get into a situation like that. But firstly, we'll deal with the mediation. Medical mediation has a lot of role players, and the main reason for that is that most of you will either have an indemnity insurer or you will be working for the state. A few people will not be insured at all and will not be involved in the state. But that means that in every mediation, there is, if I can call them, a third party that participates in the mediation. And it is that third party that behind the scenes really makes the decision. The patient is the one that comes to mediation because they feel they have been harmed. Often this has got to do with a lack of communication or the expectations they had. And it doesn't matter how good your informed consent is, how many times you try to be nice and friendly to them, if they feel, and this is often sometime after they have seen you and they have left the health facility or are no longer in your treatment, that they start talking to people and people add stories and suddenly it's negligence. So there are early warning signs though, in hospital settings especially, where the family is moaning or they come to you and they're not happy with what is happening, or they tell you they don't know what's going on, or you can just see, I mean, we all deal with humans every single day, so you can pick up when a person is not happy. For that, the prevention for me is, if you don't have a bioethical mediator, and I'll explain to you what that is. Early prevention would be to try and determine immediately what the problem is. And then if there is a mediator that you're aware of that you can contact to get a bioethical mediator on board to step in and help with dealing with the patient to prevent future litigation. Most of the indemnity insurers would have bioethical mediators on their books or will be aware of bioethical mediators that I can send to you to come and assist. It is widely used in the UK, a bioethical mediator in hospital settings, where, for instance, the healthcare professionals and the patient disagree on the treatment, or the healthcare professional and the family, where a patient can't speak for himself or herself, disagrees. The most important thing, I think, is empathy, and as I say, the empathy in a mediation is very important. And you don't have to admit liability or admit that something went wrong. And when I say admit liability, I'm speaking from the perspective that it was an adverse outcome or a complication, not negligence. You don't have to admit that to show empathy. You know, I recently dealt with a matter where the surgeon in question was so empathetic that it made the matter go away. So just showing that you understand their hurt and their anger already takes it a long way, and spending that extra 5 minutes with a patient. I was absolutely amazed the other day to meet somebody who actually schedules her appointments for 40 minutes. And I'm like, wow, okay, so, you know, that is somebody that clearly spends a lot of time explaining, especially in the initial consultation, to the patient exactly what they can expect. Visual effects, visual learning, especially also if you go to mediation, to have visual tools available so that you can show the patient and the attorney that most likely will be present and that is driving the case, to be able to draw pictures, show them where the organs are, if it was a general surgery, you know, and then just explaining to them how it came about, that specific outcome. And all of that you can do in a mediation if you weren't able to do it in a hospital setting. As you can see there, shifting blame to legal professionals is not helpful. Honestly, it's, you know, and we unfortunately get that often, that lawyers are to blame. They are doing exactly what we are doing, what you as a doctor are doing. You're taking an opportunity and you're using it to make money out of it. If somebody is referred to you and I have an elective procedure, you know, that's an opportunity you have to increase or rather to increase your experience and to look after a patient. So we can't blame that. There are some scalar ones, I'm not going to deny that, but for the majority, the medical professionals or the lawyers are like the medical professionals out there to assist people. The attorney is a complication, and I say that honestly as an advocate. An attorney is a complication in a mediation for two reasons. Both attorneys for the defendant and the attorney for the plaintiff causes a complication. The reason for that is that the attorney for the plaintiff or the patient would have a fee agreement where they have agreed to accept 25% of the final quantum. Now, that means that if you make a nuisance offer, as we call it, or the insurers call it, of say 100,000 rand, because the matter's not really worth anything, the attorney will most likely turn it down because he will only get 25,000 rand of that, and he might have been spending 800,000 rand on investigating the matter. And that is something that some of you on here might be medical legal experts and might be doing reports, and you will know what your reports cost to send out, and it can range on average from between about 20,000, depending on your speciality, to around, I've heard of experts that charge 100,000 rand for a report. So you can understand that if an attorney who pays that out of his own pocket has spent 800,000 to 1.5 million on investigating a matter, that they are not in a mediation going to accept an amount that doesn't cover their costs. So if you are a mediator or you are in a mediation with your attorney, always put that on the table as one of the aspects that could hamper the actual settlement of the mediation. Counsel, that is spelled incorrectly, sorry. Counsel here is the advocate, spelled S-E-L, of course. Voice of reason, not always. I find that some counsel, like the attorney, because remember the advocate, even though we are independent, we are getting paid by the attorney, and behind the attorney is an indemnity insurer or the state, the Department of Health, that might give a different mandate from you that actually want to settle the matter. If you are the mediator yourself, often the counsel will be a buffer between the attorney and you, so put them as close to you as possible, because they are ones that are more independent as a general rule than the attorney, because they haven't incurred all the disbursements. The medical legal experts, you can also have in a mediation an expert. I prefer to agree with the parties to just have one expert, so that it's easier. But if you decide for each party to have its own expert, or you want to be an expert in a mediation, then you will also produce a report. If there's more than one expert, you can do joint minutes. If those of you that don't know what it is are welcome to send me a private message, as that is not what we're dealing with today. Or you can all sit together and discuss it in front of the arbitrator, which is referred to in international arbitration as hot tubbing. And it's literally, it was coined by the Australians. It's literally sitting in a hot tub together and sweating through the evidence. I wrote an article on this that's available on LinkedIn if you want to go and have a look. Then the indemnity insurer. And at this point, I should thank Janawa for sponsoring this talk tonight, and also on Saturday when some of you will see me in person. And the indemnity insurer, if you are not adequately insured, make sure your property is in trust, because if you are if you go to a medical negligence through medical negligence litigation, it can be extremely costly. Even an ordinary medical negligence matter, and I'm not talking about obstetrics where a quantum can run into millions and millions, you will look at up to 20, 30 million rand in legal fees and costs that you have to pay. So if you make the decision not to be insured, you are going to have to ensure that your assets are protected, because the attorneys will come after your assets and they will attach your assets to realize that judgment if you are not adequately insured. Also, make sure that if you do have an insurer, that you make sure what your cover is, how much cover you have, for instance, for legal fees, etc., etc. I assisted one professional who only had 250,000 rand for legal costs. By the time we had finished with the response to the HPCSA, that money was gone. So make sure that you talk to your indemnity insurer, that you find out exactly what your cover is, and rather adjust your cover to the higher levels than to the lower levels. All types of insurance, be it car or household insurance, is a grudge purchase. None of us want to have insurance. We hate paying insurers. But I can tell you, it is in medical negligence, it is essential, because South Africa is becoming more and more litigious as it goes towards negligence, and the road accident fund is in shambles. So you are the next victims as medical professionals, because that's all the attorneys know. And I'm not saying that in a derogatory manner. They are exceptionally good at what they do, and I have exceptional knowledge, but they will come more after doctors if there's insurance with the road accident fund not functional anymore. Quantification, as I mentioned briefly earlier on, quantification is massive in medical negligence matters, and it is a very, very important aspect to consider when you are in a mediation. If you are the professional that is being accused, or you are the mediator, please make sure that if you are the accused, that you drag your attorney to the direction of understanding that, you know, when an offer comes in, maybe from the indemnity insurer or from the state, that is too low, because that can be very costly litigation going forward then. I can maybe give you an example of a matter I did, which was a twin CP case, and the legal costs, the matter would have gone on trial for 6 weeks, and the estimated legal costs for the two counsel, for the plaintiff, or for the defendant rather, and for 6 weeks in court was 30 million. And the quantum claim was 33 million. So the decision was made to make an economic settlement offer of 30 million, rather than risk the chance of spending 33 million on litigation and still getting a judgment of 30 against them. The risk wasn't above 50%, but it was a very high financial risk. And for that reason, the matter was settled. So economic considerations always come into settlement. And it's not just about being liable or not liable. It's something you have to take into consideration. If every matter that goes to court costs an insurer 60 million rand in paying quantum and defending the matter, then indemnity insurance, which is for most of the super specialists already unaffordable, but it will become crazy. We simply wouldn't be able to pay it. So quantification is dealt into loss of earnings. That is the money the person lost, basically being in hospital, say, for 2 or 3 months and not being paid. If they were paid, they don't qualify for a loss of earnings, unless on some other complicated legal terms, which I wouldn't bore you with. Loss of earning capacity is when they own their own business and they lost the capacity to run that business, or the business has lost money as a result of them not being there to run the business. General damages is for pain and suffering and amenities of life, and that includes everything from not being able to play soccer with your grandchildren, you know, now being constantly in pain, and that's normally a globulous amount that is awarded. And I genuinely can tell you that for the most part, we suck that out of our thumbs, because we would go and look at case law that recommends A, B, and C for, say, for instance, a drop foot, but this particular patient might have a brain injury as well now, or complications occurred and they've lost their foot. So there's never one exact case that can tell you what type of general damages is applicable. So for the most part, that is debated and settled between counsel and the attorneys, what amount of general damages would be paid. Special damages is everything they can quantify, in other words, future medical expenses, what they, you know, if their house needs to be readjusted, there will be quantity surveyors, there will be architects. For instance, with CP babies, you need a specialized bathroom so that the wheelchair can fit in. All those costs have to be taken into consideration. And that's why the quantum of these matters are so huge, and why everything cannot be dealt with in state hospitals, as the wish is often that the children should go, for instance, to a state hospital. Because the child's surroundings and the facilities they live in also need to be adjusted. Legal fees, as I indicated earlier on, a massive thing. And the attorneys will certainly take the matter to court rather and take their chances there, especially if they have a good case, if you don't settle in a manner that is beneficial to them. Bioethical mediation, I briefly explained or briefly touched on it earlier on. I am a huge proponent of bioethical mediation, and I am devastated that it is not something that is not in every single hospital setting peremptory, that where there's any dispute between a patient and a doctor or between a patient and a family, there has to be a bioethical mediator that comes in and chats to everybody. That is where you can stop litigation right there and then. When you have a independent third party, that, like in my case, is both a lawyer and experienced in medical and health law, that can assist you and can sort the thing out right there and then and be the middleman to try and settle the aspect. And I think that is something that we have to push for in hospital settings, is we need to start requesting that not just that the hospital manager is not necessarily the only person. For instance, if there is a complaint, but there's immediately a bioethical mediator appointed to assist with any complaint procedure. Okay, let's see what's happening. Okay, there we go. That's the one on, and there you see all Janawa's details. If you are not familiar with them, please go to their LinkedIn and their YouTube pages. I'm an independent advocate, but I work closely with Janawa in assisting you if you get a complaint to the Health Professions Council or have to go to litigation. So yeah, so go and have a look at all their details.